Good afternoon. Amanda Murray on behalf of Mr. Mesty.
All right. And your name, ma'am?
My name is Janice Luft, Your Honor. I am sorry that I don't have an attorney with me today. I don't mean to be disrespectful of you or the court.
Welcome to this courtroom drama, and buckle in because what you're about to see is not your typical eviction case. This is a tangled web of legal claims, medical hardships, and accusations of fraud, all colliding in front of Judge Simpson. From the opening moments, Janice enters without an attorney and immediately sets the stage with a flood of personal details, family ties to lawyers, health struggles, even radon tests in her home. This is important because it shows what often happens in court when self-represented defendants arrive overwhelmed and underprepared. Their arguments can come across as scattered. But here's the kicker. The judge is only dealing with one narrow issue: possession of the property. Yet Janice is throwing in everything from dental surgery to storage thefts, creating tension that will fuel the case. Who do you think is already at a disadvantage here? The calm judge focused on the law, or Janice battling both health and housing?
I had attorneys in my family, but they passed away. Paul Bronlick was my uncle's brother. Mark Bronlick is now a judge in Monroe. Bill Bronlick is no longer practicing. But Philip Costello did consult with me yesterday and directed me towards the type of lawyer I should be calling because of the toxic environment in the home that I've been living in that was hidden from me. And I wanted to have these to the court before now, but I wasn't able to. I need to have two teeth orally. Oh, okay.
What are the, what?
Well, I need to have a couple teeth orally extracted. So I have an abscess right now and on both sides of the upper mouth, an oral surgeon has to remove teeth. My fillings have fallen out. I have a medical report in here from May 23rd, 2022 on Asya Hameski's birthday where her friend assaulted me and injured my wrist and hand. And at that time, my weight was 115.
Hold on a moment. So what does, yeah, you don't want to just do that.
They're copies.
Copies of what?
There's copies of the assault at the urgent care. There's a copy of the Dexter oral surgeon for the beginning of this month. I haven't done it because I physically am not sure how I'm going to respond to this, and I have to be getting ready to get out. I'm getting my stuff in storage. 2 of the storage units were 2 of 30 that were broken into out on Lower Circle. So that was very upsetting to me. And also there's the activated charcoal radon test that I got from Washtenaw County showing that there were high levels of radon on every level of this 3-story home. So my bedroom was at 16.9 on the lower level. And on the upper level, the next highest room was Asya's.
Can I just do one thing for me?
Okay.
Just take a breath. All right, because
I have adrenal fatigue. I've been being treated by Dr. Shan Kong for over a year now.
okay. But the problem is you're giving me a lot of things. I mean, I think I'm a pretty smart guy, but you're giving me a lot of things that are.
Judge Simpson's response here is critical. He is politely but firmly signaling that Janice is overwhelming the record with unrelated details. This is a recurring problem in eviction cases. Defendants often want the court to hear their entire life story, hoping sympathy will outweigh the statute. But courts operate under strict boundaries. If a matter isn't legally pled or properly filed, the judge can't rule on it, no matter how heartbreaking. Notice how the judge acknowledges her stress yet redirects her back to the central question: what is before me? This move highlights the balance judges must strike, allowing someone to speak while keeping the proceedings legally relevant. The contrast is striking. Janice insists on raising radon levels, storage thefts, and even weight loss due to stress. But Judge Simpson hammers home that none of this changes the fact. This is an eviction hearing. Would you say the judge is showing patience here, or is his restraint a subtle frustration?
Thrown out of context to me. They're just things now that are
Okay.
sticking out there.
Well, their meaning behind that is, there's more than, I mean, I'm not a tenant. I am not a tenant. I brought in, I spent over $100 on color photocopies to show the condition of the house when I moved in, because their attorney is trying to, I've gotten 2 letters saying I better not damage the house. The house should have been condemned before I moved in. They've done things to the house that are wrong, and there's fraud.
Okay.
And I've been poisoned. I've been injured. In 2019, I weighed 128 pounds. Today, I got on the scale before I got showered. I weigh 100 pounds.
So here's the thing. Let's just stop for a moment. And let me just say that I don't have a written answer from you that is alleging, or a counterclaim that's alleging any of the things that I think you're trying to bring before me, which then makes it difficult for their side to then answer.
Well,
Things.
they want to know what they owe me. And I am saying that this, being in the situation I'm in this short of a period of time, it is hard for me to bring that forward. And to sit down, they're.
But ma'am, here's the only thing that right now, theoretically, is before me. They have a termination case
Yeah.
to have you leave the home.
And I said I would. I don't understand this.
Okay.
This is
And-
really disruptive to the process of moving out and getting dental care and getting rest.
Okay. So if the issue here is you moving out,
That's what I thought it was.
okay.
And then they're trying to include money and then reaching forward to put a gag order on me.
Well,
I can't do that.
ma'am, hold on. All I have is a possession case.
Here, the stakes are clarified for the first time. The judge strips away every side issue and centers the legal reality. This is not about medical bills, storage theft, or environmental hazards. It is about whether Janice must vacate the property. This moment is decisive because it resets the courtroom narrative. The judge is reminding both sides and the audience that only the question of possession matters under Michigan landlord-tenant law. Notice Janice's emotional pivot. She swears she doesn't want an eviction on her record, a powerful admission that shows how much weight that single word carries for tenants. An eviction judgment can follow someone for years, blocking housing opportunities and damaging credit. That fear is raw and very real in her voice.
Okay.
That's all I have.
Well, the letters, from them sound like something else.
Okay.
I might move out this weekend,
not-
swear to God.
Ma'am,
Judge
I am
Simpson.
not privy to those letters.
Oh,
What I have before me is a case where they have sent you notice to vacate the premise.
and I said I would
Okay. Stop there.
last time.
Just for a
Okay,
moment.
okay.
So that then they end up bringing in action so that the court will order you to leave the house if the court finds in their favor.
Yeah.
It sounds to me like on that issue, the parties are in agreement.
Yeah, if I have to sleep in my car, I will. I don't want an eviction on my record. I don't want to stay in
So-
their house.
Okay.
But I do want to have a city inspector inspect the home before I leave, so I'm not accused of damaging something that they jury rigged back in 2015 that has caused utility bills to be really high and has caused radon to be in every room of the 3-story house. They had an intake in an unfinished crawl.
Ma'am,
They've left
Ma'am,
sewage
ma'am.
down there.
ma'am,
Okay, it's just about the eviction.
really is. That's what's before me.
Yeah, so, last time we were here, I said I'd be out.
Okay, so when are you going to move out?
This exchange is a textbook example of how judges cut through noise. Janice insists she has already agreed to leave, but her repeated explanations make it sound uncertain. Judge Simpson presses her to set a firm deadline, almost as if he is negotiating terms of a settlement in real time. Notice how specific dates become the battleground. June 27th versus June 30th. For the legal system, those 3 days are trivial. But for Janice, juggling dental surgery, packing, and housing insecurity, those 3 days feel monumental. This shows how eviction cases often collapse complex, personal struggles into rigid timelines. The tension is palpable. Janice pleads for understanding, while the judge insists clarity is non-negotiable. Here's something for you to think about. Should courts give more leeway for personal circumstances, or does strict enforcement of deadlines protect fairness for landlords?
Well, we had said that it was going to be like the 27th, but you might give me 3 days to the end of the month, the 30th. And I keep saying I'll be out by the 30th, and I'll probably be out before then, but it's like, it doesn't get heard.
What doesn't get heard?
That I said I'm going to be out.
Okay, so the only one that needs to hear you at this point is me. Okay.
Okay.
So when will you leave?
I will look for, tomorrow I will start looking for an apartment.
Well, but that's not what I'm.
No, I will leave on or before the 30th of June.
Okay.
If you say that's okay. If you tell me I have to do it on the 27th, then I will do it before then.
Okay. All right. Why don't you have a seat and let me hear from the other side is that issue.
All right.
Right.
Thank you, Your Honor. My client is in agreement that she can stay until June 30th. I do want to bring forth before the court that we did file an amended complaint, and that amended complaint does seek monetary amount.
This is the turning point. Just when Janice thought the case was only about moving out, the landlord's attorney drops a bombshell. They've amended the complaint to demand payment of utility bills totaling $1,370. Suddenly, the case isn't just about possession, it's about money. This escalation shifts the balance dramatically. For Janice, who has been speaking about poverty, weight loss, and medical bills, the demand for over $1,000 feels crushing. Legally, though, this tactic is common. Landlords often add utility charges or back rent to strengthen their claim. But notice how precise the attorney is, citing DTE energy bills down to the dollar. Contrast that with Janice's vague objections about high energy costs. In court, precision often wins over passion.
For DTE
When
energy
did you?
on the 24th, May 24th.
Total amount here of 1370.30, correct?
Correct.
That's the amendment to the complaint.
Correct.
All right.
Your Honor, that's not the only amendment. I would
Okay.
just like to note for the court that when this action began, Ms. Humeski was alive.
Okay.
And my client was acting as her power of attorney. She has since passed.
Okay.
The property is owned by the trust. So now he is acting in his capacity as trustee of the trust. So the complaint was amended to correctly reflect in what capacity he was acting and who owned the property as well.
Got it. Okay. But in terms of monetary amounts, we're really talking about this 1,370.
That's what we're talking about, DTE bills. All along, there's been no disagreement that there's no lease agreement. She doesn't pay a monthly amount. We're not seeking any type of rental payment. These are costs that the estate has incurred since she has continued to remain in the property.
Okay. All right. So you can remain right where you are. Have you gotten a copy of the amended complaint?
Yeah.
Okay. I want you to turn to the page that has the chart on it.
I'm looking at it.
Okay, and it has on there the water bill energy and 3 DTE bills,
Yeah.
right? Okay. So let me ask you this. All right, and try to just succinctly answer my question. Of that amount, how much of that amount do you think you owe?
Less than half of it.
Okay, so
The water bill, I think, is the order proceeding.
is what?
I mean, I don't have the actual bills to look at, and, the high energy costs on this property is due to the HVAC system her son bought, and DTE has pointed that out regularly. There's issues in the furnace companies I had in November, December, January,
okay,
pointed out that
okay.
it's the fault of the system, that they're so high. It's not my fault. And they should be lower because
Okay, but hold on. I didn't ask all this. I didn't ask all this. So,
I'd say less than half.
So-
Less than half.
okay, so do me a favor, okay? And all I want is a number. Just, I don't want an explanation behind the number.
Okay.
Just give me a number of the 1370.
This is a classic moment in judicial efficiency. Judge Simpson is done entertaining lengthy explanations and wants one thing, a number. Courts often distill sprawling disputes into sharp, quantifiable terms. Janice resists with context, but the judge cuts her off, steering her back to what matters. When she finally says $700, it's almost a sigh of defeat, but then something shocking happens. The plaintiff accepts. This shows the raw power of negotiation in open court. Without lawyers, without lengthy filings, a $1,000 dispute gets halved in a matter of seconds. But here's the deeper insight. Janice's emotional storytelling may have softened the opposing side's stance. Even if the judge demanded clarity, her relentless narrative about costs and hardship possibly influenced that compromise.
And $700.
My client will accept that.
Okay, so here's what I
I don't want that to shut me off from any future claims on my payroll and other expenses out of pocket for doing the liner and the crawl, which is upwards, just out of pocket, a couple $1,000. And then to do that work itself, we're looking at $1,000 or $2,000. So they owe me. I want to.
okay, but hold on. When you say, well, hold on. But when you say they,
The Humesky's.
okay, but you're talking the estate now owes you that.
Yeah, because I think if I had a hearing, I could prove that
Okay,
Rick was making a lot of decisions that created toxic.
okay, but ma'am, just listen to me for a moment.
I'm trying to.
You're gonna have to make a claim against the estate for the things that you're talking about.
Here's where the complexity of probate law crashes into the eviction case. Janice insists she is owed thousands for repairs, improvements, and medical expenses. But Judge Simpson points out a hard truth. Those claims must be filed against the estate, not resolved in this eviction hearing. This is a legal fork in the road. Many pro se litigants don't understand jurisdiction, what issues belong in what court. By explaining this, Judge Simpson is essentially protecting the record. If he ruled on those claims here, it would be overturned on appeal. But the emotional weight is undeniable. Janice feels cheated, unheard, and cornered. To her, justice means recognition of every wrong. To the judge, justice means staying within his lane. This disconnect creates frustration we can feel through the screen.
Okay.
Okay, that doesn't happen typically here.
Okay.
Okay?
Okay.
All right. So what you have here in front of, what I have here in front of me is basically the property kind of itself. If you're talking about services, if you're talking about things that you did or things that should be yours as part of the estate, that happens elsewhere. I didn't want to be that kind of judge, so I'm not.
Okay.
Okay, so here's what I'm hearing, and this really would resolve this case. Okay, and that is that you will vacate the premises by the 30th of June, 2023. Or a writ of restitution could issue, or an order of eviction. And that you will pay to the plaintiff $700 for utilities.
This is the moment of resolution. Judge Simpson lays down the final conditions. Janice must leave by June 30th and pay $700. What stands out is how he frames it, not as punishment, but as a way to resolve this case. Judges often seek closure that avoids future litigation, and this order accomplishes that. The defendant gets a clear deadline without eviction on her record if she complies, and the plaintiff gets money for utilities. This is the essence of compromise in landlord-tenant disputes. But notice Janice's hesitance. She still wants recognition of her claims. Her voice carries a mix of resignation and resistance, as if agreeing to terms but still fighting for validation.
Yeah.
Can we add by June 30th as well to that?
Can you do that? Can you pay the $700 by June 30th by the time
I
you?
could write a check right now and just.
Okay,
put
then
a
we
date
could
on
do-
it, and,
We can do that. Then what? Yes,
then make sure I have the funds in my checking account.
that's fair. So then we can do that, and the judgment could then reflect that a check has been tendered in that amount.
Yeah, so I'm just wondering, Asia died on March 31st. And,
Does she have a judgment?
so they're including the March 9th bill. She was still alive, still her
Do
property.
you have a judgment for?
I don't, Your Honor.
We'll get one.
Thank you.
What were you saying, ma'am?
It doesn't matter.
No,
She
well,
was still alive on March 9th. She died on March 31st. So they included a billing. I'm trying to understand that these are billings from when he became, when she, like after she died, and then he gets the property or something.
okay, but let's look at it this way.
It's okay, 700.
Yeah, because you're not paying the whole amount of the bill, so I don't have to go per diem
Yeah,
on anything, okay? So, I mean, it would seem to me to balance out, and do it that way, and I get what you were saying about the water bill, but I think, again, that's gonna kind of balance out, because it's
Yeah,
gonna
I
either
agree.
be, yeah, it's gonna balance out.
So that doesn't reach out into any other areas. This is just about the eviction. This is money towards utilities. And I'm fine with that. When I moved in, I asked to pay rent and it was refused, and I did give her 200 cash for utilities. And,
Okay, can you print one?
yeah, I was just
Hurry. Hurry.
Separately, the, wages that weren't covered, and, there's tax stuff.
Okay, so here's what we'll do, because I'm not ruling on that, none of that's before me. This is only going to be applied to the possession of the property. So if there's other stuff that you're claiming,
Separate.
I think that's just outside, not anymore, somebody else. You get to go downtown for that. Yeah. Pardon?
With my friend O'Deal, she's a registration.
It depends on what you want to say, ma'am.
I just want to say that this woman took care of his mother for 7 years, night and day. And I feel it's not fair the way he's treating her now. It's just not fair.
No, it's not.
I don't think caretaker should be treated that way. I have been a registered nurse for 30 years, and it breaks my heart to see the way this family takes care of this caretaker.
This moment is striking. After all the legal back and forth, Janice appeals to morality. She shifts from contracts and utilities to fairness, compassion, and the dignity of caretakers. She reminds the court she has been a registered nurse for 30 years and frames her struggle as symbolic of how society mistreats caregivers. This rhetorical shift is powerful, but it also highlights her disadvantage. Courts deal in statutes, not morality. Judge Simpson acknowledges her words, but doesn't allow them to alter the ruling. Still, for viewers, this moment adds emotional depth. It's no longer just a tenant versus landlord issue, but a broader commentary on justice, sacrifice, and fairness.
All right, thank you.
It's really not fair.
I do have a check dated today in the amount of $700 from the defendant. I will state on the record that my client will not cash that check today.
All right,
We'll
Very-
cash it after tomorrow.
okay, all right. I think Monday's a bank holiday, so. Well, you can do it Saturday, I guess.
It was a matter of, before I move out, since twice it suggested in letters that I might damage the property, I'd like to have a building inspector look at the property.
Okay, typically that's not how it's done, okay? So typically what's going to occur is there'll be a move out. They may do a walkthrough to inspect. If they see something that might, how long have you been in the premises?
6 years cleaning it up
Okay.
and fixing it.
Okay, all right. So if they see something that might be beyond ordinary wear and tear, then there's a whole procedure by which they, and statutory scheme that they would have to claim that. So there really isn't going to be a need for an inspector prior to your leaving. That doesn't mean that if you want to call the city of Ann Arbor and they can get out there before the 30th,
I can do that.
you can. All right.
Okay, thank you.
But I'm not making it part of this decision in
No.
this case that happened.
And with that, the gavel falls figuratively, even if not literally. The case ends with Janice ordered to vacate by June 30th and pay $700 toward utilities. Judge Simpson stays firm. No inspectors, no side claims, no distractions, just a narrow ruling on possession and costs. This case illustrates the razor-thin scope of eviction law. For Janice, it feels incomplete. Her broader grievances about fraud, radon, and medical harm remain unheard. For the court, it's resolved, the house returns to the estate, and the dispute over money is settled. What makes this case fascinating is the collision of human struggle against legal procedure. We saw raw emotion clash with strict rules, and in the end, the law prevailed. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.